Chapter 4, Application of Penalties. Section 1, Rules for the application of penalties to the persons criminally liable and for the graduation of the same. Article 46 to Article 59 of Act Number 3815, Revised Penal Code of the Philippines. Article 46, Penalty to be imposed upon principals in general. The penalty prescribed by law for the commission of a felony shall be imposed upon the principals in the commission of such felony. Whenever the law prescribes a penalty for a felony is general terms, it shall be understood as applicable to the consummated felony. Article 47. In what cases the death penalty shall not be imposed? So the death penalty shall be imposed in all cases in which it must be imposed under existing laws, except in the following cases. First, when the guilty person be more than 70 years of age. 2. When upon appeal or revision of the case by the Supreme Court, all the members thereof are not unanimous in their voting as to the propriety of the imposition of the death penalty. For the imposition of said penalty or for the confirmation of a judge of the inferior court imposing the death sentence, the Supreme Court shall render its decision per curiam, which shall be signed by all justices of the said court, unless some members or members thereof shall have been disqualified from taking part in the consideration of the case, in which even the unanimous vote and signature of only the remaining justice shall be required. Article 48, Penalty for complex crime. When a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Article 49. Penalty to be imposed upon the principals when the crime committed is different from that intended. In cases in which the felony committed is different from that which the offender intended to commit, the following rules shall be observed. First, if the penalty prescribed for the felony committed be higher than that corresponding to the offense which the accused intended to commit, the penalty corresponding to the latter shall be imposed in its maximum period. 2. If the penalty prescribed for the felony committed be lower than that corresponding to the one which the accused intended to commit, the penalty for the former shall be imposed in its maximum period. Third, the rule established by the next preceding paragraph shall not be applicable if the acts committed by the guilty person shall also constitute an attempt or frustration of another crime. If the law prescribes a higher penalty for either of the latter offenses, in which case the penalty provided for the attempted or the frustrated crime shall be imposed in its maximum period. Article 50. Penalty to be imposed upon principals of a frustrated crime. The penalty next lower in degree than that prescribed by law for the consummated felony shall be imposed upon the principal in a frustrated felony. Article 51, Penalty to be imposed upon principals of attempted crimes. A penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the principals in an attempt to commit a felony. Article 52, Penalty to be imposed upon accomplices in consummated crime. The penalty next lower in degree than that prescribed by law for the consummated shall be imposed upon the accomplices in the commission of a consummated felony. Article 53, penalty to be imposed upon accessories to the commission of a consummated felony. The penalty lower by 2 degrees than that prescribed by law for the consummated felony shall be imposed upon the accessories to the commission of a consummated felony. Article 54, penalty to impose upon accomplices in a frustrated crime. The penalty next lower in degree than prescribed by law for the frustrated felony shall be imposed upon the accomplices in the commission of a frustrated felony. Article 55, penalty to be imposed upon accessories of a frustrated crime. The penalty lower by 2 degrees than that prescribed by law for the frustrated felony shall be imposed upon the accessories to the commission of a frustrated felony. Article 56 is penalty to be imposed upon accomplices in an attempted crime. The penalty next lower in degree than that prescribed by law for an attempt to commit a felony shall be imposed upon the accomplices in an attempt to commit the felony. Article 57, penalty to be imposed upon accessories of an attempted crime. The penalty lower by 2 degrees than that prescribed by law for the attempted felony shall be imposed upon the accessories of the attempted to commit a felony. Article 58, additional penalty to be imposed upon certain accessories. So those accessories falling within the terms of paragraph 3 of Article 19 of this code who should act with abuse of their public functions shall suffer the additional penalty of absolute perpetual disqualification if the principal offender shall be guilty of a grave felony, and that of absolute temporary disqualification if he shall be guilty of a less grave felony. Last article, Article 59, penalty to be imposed in case of failure to commit the crime because the means employed or the aim sought are impossible. So when the person intending to commit an offense has already performed the acts for the execution of the same, but nevertheless the crime was not produced by reason of the fact that the act intended was by its nature one of impossible accomplishment or because the means employed by such person are essentially inadequate to produce the result desired by him, the court, having in mind the social danger and the degree of criminality shown by the offender, shall impose upon him the penalty of arresto minor or a fine from 200 to 500 pesos.